Parliament chapter. The Parliament is the legislative organ of the Union government. It occupies a preeminent and central position in the Indian democratic political system due to adoption of parliamentary form of government, also known as the Westminster model of the government. Article 79 to 122 in Part 5 of the Constitution deals with the organization, composition, and duration. Organization, composition, duration of officers, procedures, privileges, powers, and so on of the Parliament. Article 79 to 122 in Part 5. Organization of the Parliament. Under the Constitution, the Parliament of India consists of three parts: the President, the Council of States, and the House of the People. In 1954, the Hindi names Rajya Sabha and Lok Sabha were adopted by the Council of States and House of People respectively. The Rajya Sabha is the house. The Rajya Sabha is the upper house, that is second chamber of the House of the or the House of the Elders, and the Lok Sabha is the lower house, that is the first chamber of the Popular House. The Rajya Sabha represents the states and UTs of the Indian Union, while the latter represents the people of the India as a whole. Though the President of India is not a member of either House of the Parliament and does not sit in the Parliament to attend its meetings, he is an integral part of the Parliament. This is because a bill passed by both the Houses of the Parliament cannot become a law without the President's assent. He also performs certain functions relating to the proceedings of the Parliament. For example, he summons and prorogues both the houses, dissolves the Lok Sabha, addresses both the houses, issues ordinances when they are not in session, and so on. In this respect, the framers of the Indian Constitution relied on the British pattern rather than the American pattern. In Britain, the Parliament consists of the Crown, the House of Lords, that is the upper house, and the House of Commons, that is the lower house. By contrast, the American president is not an integral part of the legislature. In USA, the legislature, which is known as the Congress, consists of Senate, that is upper house, and the House of Representatives, that is the lower house. The parliamentary form of government emphasized on the interdependence between the legislative and the executive organs. Hence, we have the president in parliament, like the crown in the parliament in Britain. The presidential form of government, on the other hand, lays stress on the separation of legislative and executive organs. Hence, the American president is not regarded as a constituent part of the Congress. Composition of the two houses, that is composition of the Rajya Sabha. The maximum strength of the Rajya Sabha is fixed at 250, out of which 238 are to be the representatives of the states and the UTs that are elected directly, and 12 are nominated by the President. At present, RS has 245 members. Of these, 229 members represent the states, 4 members represent the UT, and 12 members represent the members are nominated by the President. The fourth schedule of the Constitution deals with the allocation of seats in the Rajya Sabha to the states and UTs. Fourth schedule, Article 4 and 80. Representation of states. The representatives of states in the Rajya Sabha are elected by the elected members of state legislative assemblies. The election is held in accordance with the system of the proportional representation by means of single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of population. Hence, the number of representatives varied from state to state. For example, UP has 31 members, while Tripura has 1 member only. However, in USA, all states are given equal representation in the Senate respective of their population. USA has 50 states and the Senate has 100 members, 2 from each state. Representation of UTs. The representation of each UT in the Rajya Sabha are indirectly elected by the members of the Electoral College specially constituted for the purpose. This election has also held in accordance with the system of proportional representation by means of single transferable vote. Out of the 7 union territories, only 2, that is Delhi and Puducherry, have representation in the Rajya Sabha. The populations of the other 5 union territories are too small to have any representation in the Rajya Sabha. Nominated members. The President nominates 12 members to the Rajya Sabha from people who have special knowledge or practical experience in art, literature, science, and social services. The rationale behind this principle of nomination is to provide eminent persons a place in the Rajya Sabha without going through the process of election. It should be noted here that the American Senate has no nominated members. Composition of Lok Sabha. The maximum strength of the Lok Sabha is fixed at 552. Out of this, 530 members are to be representatives of the states, 20 members are to be the representatives of the UTs, and 2 members are to be nominated by the president from the Anglo-Indian community. These 2 members are now done away with from the most recent, that is from the 17th Lok Sabha. At present, Lok Sabha has 545 members. Of these, 530 members are representatives of the states and 13 members represent the UTs and to एंग्लो इंडियन. ये देखना पड़ेगा कि जो बाकी 2 हैं वो कैसे अप्रोप्रिएट करेगी, इलेक्टेड में डालती हैं कि भी स्टेट्स में डालने की यूटीज में डालें. Okay, representation of states. The representatives of the states in the Lok Sabha are directly elected by the people from the territorial constituencies in the state. The election is based on the principle of universal adult franchise. Every Indian citizen who is above 18 years of age and who is not disqualified under the provisions of the constitution or any law is eligible to vote at such election. The voting age was reduced from 21 to 18 years in the 61st Constitution Amendment Act 1988. 61st Constitution Amendment Act 1988. Representation of UTs. The Constitution has empowered the Parliament to prescribe the manner of choosing the representatives of the UTs in the Lok Sabha. Accordingly, the Parliament has enacted the UT Direct Elections to the House of People Act 1965, by which the members of the Lok Sabha from the UTs are also chosen by direct elections. Nominated members. The President can nominate 2 members from the Anglo-Indian community if the community is not adequately represented in the Lok Sabha. Originally, this provision was to operate till 1960 but has been extended till 2020 by the 95th Amendment Act of 2009. Originally, this provision was to operate till 1960 but has been extended till 2020 by the 95th Amendment Act 2009, which has been done away with in the recent 17th after the in the 17th Lok Sabha. Yes. System of elections to the Lok Sabha. The various aspects related to the system of elections to the Lok Sabha are as follows. Territorial constituencies. For the purpose of holding direct elections to the Lok Sabha, each state is divided into territorial constituencies. In this respect, the Constitution makes the following 2 provisions. Each state is allotted a number of seats in the Lok Sabha in such a manner that the ratio between that number and its population is the same for all states. This provision does not apply to a state having a population of less than 6 million. Each state is divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of the seats allotted to it is the same throughout the state. In brief, the Constitution ensures that there is uniformity of representation in 2 respects, between the different states and between the different constituencies in the same state. The expression population means the population as ascertained at the preceding census, of which the relevant figures have been published. Readjustment after each census. After every census, a readjustment is to be made in allocation of seats in the Lok Sabha to the states and division of each state into territorial constituencies. The Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, the Parliament has enacted the Delimitation Commission Acts in 1952, 1962, 72 and 2002 for this purpose. The 42nd Amendment Act of 1976 froze the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. This ban on the readjustment was extended to another 25 years, that is up to year 2026 by 84th Amendment Act of 2001. With the same objective of encouraging population limiting measures, the 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies. Readjustment and rationalization of territorial constituencies in the states on the basis of population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the limitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the number of seats allotted to each state in the Lok Sabha. Reservation of seats for SCs and STs. Though the Constitution has abandoned the system of communal representation, it provides for the representatives of states for the scheduled castes and scheduled tribes in the Lok Sabha on the basis of population ratios. Originally, this reservation was to operate for 10 years, that is up to 1960, but it has been extended continuously since then by 10 years each time. Now, Now, under the 95th Amendment Act of 2009, this reservation is to last until 2020. अब ये देखना पड़ेगा 2020 में कौन सा अमेंडमेंट लाया इन्होंने. Those seats are representative for scheduled caste and scheduled tribes. They are elected by all the voters in a constituency without any separate electorate. A member of scheduled caste and scheduled tribe is also not debarred from contesting a general, that is non-reserved seats. The 84th CA of 2001 provides for refixing of the reserved seats on the basis of population figures of 1991 census as applied to the rationalization of general seats. Later, the 87th CA of 2003 provides for the refixing of the reserved seats on the basis of 2001 census and not 1991 census. Proportional representation not adopted. The other constitution has adopted the system of proportional representation in the case of Rajya Sabha. It has not preferred the same in the case of the Lok Sabha. Instead, it has adopted the system of territorial representation for the election of the members to the Lok Sabha. Under territorial representation, every member of the legislature represents a geographical area known as constituency. From each constituency, only one representative is elected. Hence, such a constituency is known as a single member constituency. In this system, a candidate who secures majority of the votes is declared elected. This simple majority system of representation does not represent the whole electorate. In other words, it does not secure due representation to minorities, that is small groups. The system of proportional representation aims at removing the defects of territorial representation. Under this system, all the elections of the people get representation in proportion to their number. Even the smallest section of the population gets its due share of representation in the legislature. There are two kinds of proportional representation, namely the single transferable vote system and the list system. In India, the single transferable vote system is adopted for the election of the members of the Rajya Sabha and state legislative councils and for electing the president and the vice president. Though some members of the Constituent Assembly had advocated the system of proportional representation for the election of members to the Lok Sabha, the Constitution has not adopted the system due to the two reasons. First, difficulty for the voters to understand the system, which is complicated due to low literacy scale in the country, and second, unsuitability to the parliamentary government due to the tendency of the system to multiply political parties, leading to instability in government. Additionally, the system of proportional representation has the following demerits. It is highly expensive. It does not give any scope for organizing by elections. It eliminates intimate contact between voters and representatives. It promotes minority thinking and group interests. It increases the significance of party system and decreases that of voter. Duration of the two houses. Duration of the Rajya Sabha. The Rajya Sabha, first constituted in 1942, Rajya Sabha is a continuing chamber. That is, it is a permanent body and not subject to dissolution. However, 1/3 of its members retire every second year. Their seats are filled up by the fresh elections and presidential nominations at the beginning of every third year. The retiring members are eligible for re-election and renomination any number of times. The Constitution has not fixed the term of office of members of the Rajya Sabha and left it to the Parliament. Accordingly, the Parliament, in the Representation of the People Act 1951, provided that the term of office of a member of the Rajya Sabha shall be 6 years. The Act also empowered the President of India to curtail the term of members chosen in the first Rajya Sabha. In the first batch, it was decided by lottery as to who should retire. Further, the Act also authorized the President to make provisions to govern the order of retirement of the members of the Rajya Sabha. Duration of Lok Sabha. Unlike the Rajya Sabha, the Lok Sabha is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections, after which it automatically dissolves. However, the President is authorized to dissolve the Lok Sabha at any time, even before the completion of 5 years, and this cannot be challenged in a court of law. Further, the term of the Lok Sabha can be extended during the period of national emergency via a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Membership of Parliament. Qualifications. The Constitution lays down the following qualifications of the persons to be chosen a member of the Parliament. First, he must be a citizen of India. Second, he must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In his oath of affirmation, he swears to be a true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India. Third, he must not be less than 30 years of age in the case of the Rajya Sabha and not less than 25 years of age in the case of Lok Sabha. He must possess other qualifications prescribed by the Parliament. The Parliament has laid down the following additional qualifications in the Representation of People Act 1951. He must be registered as an elector of a parliamentary constituency. This is same in the case of both the Rajya Sabha and the Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an elector in that particular state was dispensed with in 2003. In 2006, the Supreme Court upheld the constitutional validity of this change. Second, he must be a member of scheduled caste or scheduled tribe in any state or union territory if he wants to contest a seat reserved for them. However, a member of scheduled caste or scheduled tribe can also contest a seat not reserved for them. Disqualifications. Under the Constitution, a person shall be disqualified for being elected as a member of the Parliament if he holds any office of profit under the Union on the state government, except that of a minister or any other office exempted by the Parliament, if he is of unsound mind and stands so declared by the court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizen of a foreign state or is under any acknowledgement of allegiance to a foreign state, and if he is so disqualified under any law made by the Parliament. The Parliament has laid down the following additional disqualifications in the Representation of People Act 1951. He must not have been found guilty of certain election offences or corrupt practices in the elections. He must not have been convicted for any offence resulting in imprisonment for 2 or more years. But detention of a person under a preventive detention law is not a disqualification. He must not have failed to lodge an account of his election expenses within the time. He must not have any interest in the government contracts, works and services. He must not be a director or managing agent, nor hold an office of profit in a corruption in which the government has at least 25% share. He must not have been dismissed from the government service for corruption or disloyalty to the state. He must not have been convicted for promoting enmity between different groups or for the offense of bribery. He must not have been punished for preaching or practicing social crimes such as untouchability, dowry and sati. On the question whether a member is subject to any of the above disqualification, the President's decision is final. However, he should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified from being a member of the Parliament if he is so disqualified on the ground of defection under the provisions of the 10th schedule. A member incurs disqualification under the defection law. First, if he voluntarily gives up the membership of the political party on whose ticket he is elected to the House. Second, if he votes or abstains from voting in the House contrary to any direction given by his political party. Third, if any independently elected member joins any political party. Fourth, if any nominated member joins any political party after the expiry of 6 months. The question of disqualification under the 10th schedule is decided by the chairman in the case of the Rajya Sabha and speaker in the case of Lok Sabha and not by the President of India. In 1992, Supreme Court ruled that the decision of the chairman speaker in this regard is subject to judicial review. Vacating of seats. In the following cases, a member of parliament vacates his seats. First, in case of double membership, a person cannot be member of both the houses of the parliament at the same time. Thus, the Representation of People Act 1951 provides for the following. If a person is elected to both the houses of the parliament, he must intimate within 10 days in which house he desires to serve. In default of such intimation, his seat in the Rajya Sabha becomes vacant. If a sitting member of one house is also elected to the other house, his seat in the first house becomes vacant. If a person is elected to 2 seats in a house, he should exercise his option for the one, otherwise both seats become vacant. If a person is elected to 2 seats in a house, he should exercise his option for one, otherwise both seats become vacant. Similarly, a person cannot be a member of both the parliament and the state legislature at the same time. If a person is so elected, his seat in the parliament becomes vacant if he does not resign his seat in the state legislature within 14 days. Disqualification. If a member of parliament becomes subject to any of the disqualifications specified in the constitution, his seat becomes vacant. Here, the list of disqualifications also include the disqualification on the ground of defection under the provisions of the 10th schedule of the constitution. Resignation. A member may resign his seat by writing to the chairman of the Rajya Sabha or speaker of Lok Sabha, as the case may be. The seat falls vacant when the resignation is accepted. However, the chairman speaker may not accept the resignation if he is satisfied that it is not voluntary or genuine. Absence. A house can declare the seat of a member vacant. The house can declare the seat of a member vacant if he is absent from all the meetings for a period of 60 days without its permission. In computing the period of 60 days, no account shall be taken of any period during which the House is prorogued or adjourned for more than 4 consecutive days. Other cases. A member has to vacate his seat in the parliament if his election is declared void by the court, if he is expelled by the House, if he is elected to the office of the Vice President or the President, and if he is appointed to the office of the Governor of a state. If a disqualified person is elected to the parliament, the constitution lays down no procedure to declare the election void. This matter is dealt by the Representation of People Act 1951, which enables the High Court to declare an election void if a disqualified candidate is elected. The aggrieved party can appeal to the Supreme Court against the order of a High Court in this regard. Oath and affirmation. Every member of either house of the parliament, before taking his seat in the house, has to make and subscribe to an oath or affirmation before the president or some a person appointed by him for this purpose. In this oath or affirmation, a member of the parliament swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, and to faithfully discharge the duty upon which he is about to enter. Unless a member takes the oath, he cannot vote and participate in the proceedings of the House and does not become eligible to parliamentary privileges and immunities. A person is liable to a penalty of Rs 500 for each day he sits or votes as a member in a house in the following conditions: before taking and subscribing to the prescribed oath or affirmation, or when he knows that he is not qualified or that he is disqualified for its membership, or when he knows that he is prohibited from sitting or voting in the house by virtue of any parliamentary law. Salaries and allowances. Members of either house of the parliament are entitled to receive such salaries and allowances as may be determined by the parliament, and there is no provision of pension in the constitution. However, parliament has provided pension to the members. In 1954, the parliament enacted the Salaries, Allowances and Pensions of the Members of the Parliament Act. In 2010, ठीक है. In 1976, the members are also entitled to a pension on a graduated scale for each 5-year term as members of either house of the parliament. Besides, they are provided with travelling facilities, free accommodation, telephone, vehicle advance, medical facilities, and so on. The salaries and allowances of the Speaker of the Lok Sabha and Chairman of the Rajya Sabha are also determined by the Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of the Parliament. In 1953, the Parliament elected the Salaries and Allowances of Officers of the Parliament Act. Under this Act, the Parliament has fixed the salaries as well as the allowances of both the Speaker and the Chairman, presiding officers of Parliament. Each house of the parliament has its own presiding officer. There is a speaker and a deputy speaker for the Lok Sabha and the chairman and deputy chairman for the Rajya Sabha. A panel of chairpersons for the Lok Sabha and a panel of vice chairpersons for the Rajya Sabha is also appointed. Speaker of Lok Sabha, election and tenure. The speaker is elected by the Lok Sabha from amongst its members as soon as may be after its first sitting. Whenever the office of speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. The date of election of the speaker is fixed by the president. Usually, the speaker remains in office during the life of the Lok Sabha. However, he has to vacate his office earlier in any of the following 3 cases: if he ceases to be a member of the Lok Sabha, if he resigns by writing to the deputy speaker, and if he is removed by a resolution passed by the majority of all the members of the Lok Sabha. Such a resolution can be moved only after giving 14 days advance notice. When a resolution for the removal of the Speaker is under consideration of the House, he cannot preside at the sitting of the House, though he may be present. However, he can speak and take part in the proceedings of the House at such a time, and vote in the first instance, though not in the case of inequality of votes. It should be noted here that whenever the Lok Sabha is dissolved, the Speaker does not vacate his office and continues till the newly elected Lok Sabha meets. Roles, powers, and election functions. The Speaker is the head of the Lok Sabha and its representatives. He is the guardian of the powers and privileges of the members, the House as a whole, and its committees. He is the principal spokesman of the House, and his decision in all parliamentary matters is final. He is thus much more than merely the presiding officer of the Lok Sabha. In these capacities, Speaker is vested with vast, varied, and vital responsibilities and enjoys great honor, high dignity, and supreme authority within the House. The Speaker of Lok Sabha derives his power and duties from the three sources, that is, the Constitution of India, the rules of procedure and conduct of business of the Lok Sabha, and the parliamentary conventions, residuary powers that are unwritten or unspecified in the rules. Altogether, he has the following powers and duties. Speaker maintains order and decorum in the House for conducting its business and regulating its proceedings. This is his primary responsibility, and he has final power in this regard. Speaker is the final interpreter of the provisions of the Constitution of India, the rules of procedure and the conduct of the business of the Lok Sabha, and the parliamentary precedents within the House. Speaker adjourns the House or suspends the meeting in the absence of a quorum. The quorum to constitute a meeting of a House is 1/10 of the total strength of the House. Speaker does not vote in the first instance, but he can exercise a casting vote in the case of a tie. In other words, only when the House is divided equally on any question, Speaker is entitled to vote. Such vote is called casting vote, and its purpose is to resolve a deadlock. However, he can speak and take part in the proceedings of the House at each time, at such time when a resolution for his removal has been considered, and vote in the first instance. So, in a resolution for the removal of the Speaker of the Lok Sabha, he can vote in the first instance, though not in the case of inequality of votes. But in normal circumstances, he cannot vote in the normal times, but only in the case of equality of votes. Okay. Speaker presides over a joint sitting of two houses of the Parliament. Such a sitting is summoned by the President to settle a deadlock between the two houses of the bill. Speaker can allow a secret sitting of the houses at the request of the leader of the House. When the House sits in secret, no stranger can be present in the chamber, lobby, or galleries, except with the permission of the Speaker. Speaker decides whether a bill is a money bill or not, and his decision on this question is final. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President for assent, the Speaker endorses on the bill his certificate that it is a money bill. Speaker decides the question of disqualification of a member of the Lok Sabha arising on the ground of defection under the provisions of the 10th schedule. In 1992, the Supreme Court ruled that the decision of the Speaker in this regard is subject to judicial review. Speaker acts as the ex officio chairman of the Indian Parliamentary Group of the Inter-Parliamentary Union. Speaker also acts as the ex officio chairman of the Conference of Presiding Officers of Legislative Bodies in the country. Speaker appoints the chairman of all the parliamentary committees of the Lok Sabha and supervises their functioning. Speaker himself is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purpose Committee. Business Advisory Committee, Rules Committee, and the General Purpose Committee. Independence and impartiality. As the office of the Speaker is vested with the great prestige, position, and authority, independence and impartiality becomes its sine qua non. The following provisions ensure the independence and impartiality of the office of the Speaker. He is provided with the security of tenure. He can be removed only by a resolution passed by the Lok Sabha by an absolute majority. That is a majority of the total members of the House, and not by an ordinary majority. That is a majority of the members of the President and voting in the House. This motion of removal can be considered and discussed only when it has the support of at least 50 members, 50 members. Speaker's salaries. and allowances are fixed by the Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of the Parliament. Speaker's work and conduct cannot be discussed and criticized in the Lok Sabha except on the substantive motion. Speaker's power of regulating procedure or conducting business or maintaining order in the House are not subject to the jurisdiction of any court. Speaker cannot vote in the first instance. Speaker can vote. Speaker can only exercise a casting vote in the event of a tie. This makes the position of the Speaker impartial. Speaker is given a very high position in the order of precedence. He is placed in the 7th rank along with the Chief Justice of India. This means he has a higher rank than all the cabinet ministers except the Prime Minister or the Deputy Prime Minister. In Britain, the Speaker is strictly a non-party man. There is a convention that the Speaker has to resign from his party and remain politically neutral. This healthy convention is not fully established in India, where the Speaker does not resign from the membership of his party on his election to the exalted office. Deputy Speaker of the Lok Sabha. Like the Speaker, the Deputy Speaker is also elected by the Lok Sabha itself from amongst its members. Deputy Speaker is elected after the election of the Speaker has taken place. The date of the election of the Deputy Speaker is fixed by the Speaker. Whenever the office of the Deputy Speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Lok Sabha. However, Deputy Speaker may vacate his office earlier in any of the following three cases. First, if he ceases to be a member of the Lok Sabha, if he resigns by writing to the Speaker. Second, and third, if he is removed by a resolution passed by the majority of all the members of the Lok Sabha. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. Deputy Speaker also acts as the Speaker when the latter is absent from the sitting of the House. In both the cases, he assumes all the powers of the Speaker. Deputy Speaker also presides over the joint sitting of both the Houses of the Parliament in case the Speaker is absent from such a sitting. It should be noted here that the Deputy Speaker is not subordinate to the Speaker. He is directly responsible to the House. The Deputy Speaker has one special privilege, that is, whenever he is appointed as a member of the Parliamentary Committee, he automatically becomes its chairman. Like the Speaker, the Deputy Speaker, while presiding over the House, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when the resolution for the removal of the Deputy Speaker is under consideration of the House, Deputy Speaker cannot preside at the sitting of the House, though he may be present. When the Speaker presides over the House, the Deputy Speaker is like any other ordinary member of the House. He can speak in the House, participate in its proceeding, and vote on any question before the House. The Deputy Speaker is entitled to a regular salary and allowances fixed by the Parliament and charged on the Consolidated Fund of India. Up to 10th Lok Sabha, both the Speaker and Deputy Speaker were equally from the ruling party. Since 11th Lok Sabha, there has been a consensus that the Speaker comes from the ruling party or ruling alliance and the post of Deputy Speaker goes to the main opposition party. The Speaker and the Deputy Speaker, while अभी Deputy Speaker कौन है, रूलिंग पार्टी से कि नॉन रूलिंग पार्टी से, देखना पड़ेगा. The Speaker and the Deputy Speaker, while assuming their office, do not make and subscribe any separate oath or affirmation. The institutions of the Speaker and Deputy Speaker originated in India in 1921 under the provisions of the Government of India Act of 1919, also Montfort Reforms. At the same time, the Speaker and Deputy Speaker were called the President and Deputy Speaker respectively, and the same nomenclature continued till 1947. Before 1921, the Governor General of India used to preside over the meetings of the Central Legislative Council. In 1921, the Frederick White and Sachidanand Sinha were appointed by the Governor General as the first Speaker and the first Deputy Speaker respectively of the Central Legislative Assembly. In 1925, Vittal Bhai J. Patel became the first Indian to be elected Speaker of the Central Legislative Assembly. The Government of India Act of 1935 changed the nomenclature of the President and Deputy President of the Central Legislative Assembly to the Speaker and the Deputy Speaker respectively. However, the old nomenclature continued till 1947 as the federal part of the 1935 Act was not implemented. G.V. Mavalankar and Anantha Sayanam Iyengar. G.V. Mavalankar and Anantha Sayanam Iyengar had the distinction of being the first speaker and the first deputy speaker respectively of the Lok Sabha. G.V. Mavalankar also held the post of speaker in the Constituent Assembly, that is legislative, as well as the provisional parliament. Mavalankar held the post of speaker of the Lok Sabha continuously for 1 decade from 1946 to 56. Panel of chairpersons of the Lok Sabha. Under the rules of the Lok Sabha, the speaker nominates from amongst the members a panel of not more than 10 chairpersons. Any of them can preside of the house in the absence of the speaker or deputy speaker. He has the same powers as the speaker when so presiding. He holds office until a new panel of chairpersons is nominated. When a member of the panel of the chairpersons is also not present, any other person is determined by the house acts as the speaker. It must be emphasized here that a member of the panel of chairpersons cannot preside over the house when the office of the speaker and the deputy speaker is vacant. So, only in case of absence of speaker and deputy speaker, the panel of chairperson can preside, but not in case of vacancy. During such a time, that is in vacancy, the speaker's duties are to be performed by such member of the house as the president may appoint for the purpose. And the elections are held as soon as possible to fill the vacant post. Speaker pro tem. As provided by the Constitution, the Speaker of the last Lok Sabha vacates his office immediately before the first meeting of the newly elected Lok Sabha. Therefore, the President appoints a member of the Lok Sabha as the Speaker pro tem. Usually, the senior-most member is elected for this. The President himself administers oath to the Speaker pro tem. The Speaker pro tem has all the powers of the Speaker. Speaker pro tem presides over the first sitting of the newly elected Lok Sabha. His main duty is to administer oath to the new members. He also enables the House to elect the new Speaker. When the new Speaker is elected by the House, the office of the Speaker pro tem ceases to exist. Hence, this office is a temporary office existing for a few days. Chairman of Rajya Sabha. The presiding officer of the Rajya Sabha is known as Chairman. The Vice President of India is the ex officio chairman of the Rajya Sabha. During any period when the Vice President acts as a President or discharges the functions of the President, he does not perform the duties of the office of the office of the Chairman of the Rajya Sabha. The Chairman of the Rajya Sabha can be removed from his office only if he is removed from the office of the Vice President. As a presiding officer, the power and functions of the Chairman in the Rajya Sabha are similar to those of the Speaker in the Lok Sabha. However, the Speaker has two special powers which are not enjoyed by the Chairman. The Speaker decides whether a bill is a money bill or not, and his decision on this question is final. The Speaker presides over a joint sitting of the two houses of the Parliament. Unlike the Speaker, who is a member of the House, the Chairman is not a member of the House, but like the Speaker, the Chairman also cannot vote in the first instance. He too can cast a vote in the case of an equality of votes. The Vice Presidents cannot preside over a sitting of the Rajya Sabha as its chairman when the resolution for his removal is under consideration. However, he can be present and speak in the House and can take part in its proceedings without voting, even at such a time when the Speaker can vote in the first instance when the resolution for his removal is under consideration of the Lok Sabha. As in the case of the Speaker, the salaries and allowances of the chairman are also fixed by the Parliament. They are charged on the consolidated fund of India and thus are not subject to the annual vote of the Parliament. During any period when the Vice President acts as President or discharges the functions of the President, he is not entitled to any salary or allowance payable to the Chairman of the Rajya Sabha, but he is paid the salary and allowance of the President during such a time. Deputy Chairman of Rajya Sabha. The Deputy Chairman is elected by the Rajya Sabha itself from amongst its members. Whenever the office of the Deputy Chairman falls vacant, the Rajya Sabha elects another member to fill the vacancy. The Deputy Chairman vacates his office in any of the following three cases: if he ceases to be a member of the Rajya Sabha, if he resigns by writing to the Chairman, and if he is removed by a resolution passed by the majority of all the members of the Rajya Sabha. Such a resolution can be removed only after giving 14 days advance notice. The Deputy Chairman performs the duties of the Chairman's office when it is vacant or when the vice president acts as the president or discharges the functions of the president. He also acts as the chairman when the latter is absent from the sitting of the house. In both the cases, he has all the powers of the chairman. It should be emphasized here that the deputy chairman is not subordinate to the chairman. He is directly responsible to the Rajya Sabha. Like the chairman, the deputy chairman, while presiding over the house, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the deputy chairman is under consideration of the house, he cannot preside over a sitting of the house, though he may be present. When the chairman presides over the house, the deputy chairman is like any other ordinary member of the house. He can speak in the house, participate in its proceedings, and vote on any question before the house. Like the chairman, the deputy chairman is also entitled to a regular salary and allowance. They are fixed by Parliament and are charged on the Consolidated Fund of India. Panel of Vice Chairmen of Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from amongst the members a panel of vice chairpersons. Any one of them can preside over the house in the absence of chairman or the deputy chairman. He has the same power as the chairman when so presiding. He holds office until a new panel of vice chairpersons is nominated. When a member of the panel of the vice chairpersons is also not present, any other person as determined by the house acts as a chairman. It must be emphasized here that a member of the panel of vice chairpersons cannot preside over the house when the office of the chairman or the deputy chairman is vacant. Okay, so they cannot preside in case of the vacancy, but only in the case of absence. During such time, the chairman's duties are to be performed by such members of the house as the president may appoint for the purpose. The elections are held as soon as possible to fill the vacant post. Secretariat of Parliament. Each house of the Parliament has separate secretarial staff of its own, though there can be some posts common to both the houses. Their recruitment and service conditions are regulated by the Parliament. The Secretariat of each house is headed by a Secretary General. He is a permanent officer and is appointed by the presiding officer of the House. Leaders in the Parliament. Leader of the House. Under the rules of the Lok Sabha, the leader of the House means the Prime Minister. If he is a member of the Lok Sabha or the minister who is a member of the Lok Sabha and is nominated by the Prime Minister to function as the leader of the Lok Sabha. There is also a leader of the House in the Rajya Sabha. He is a minister and a member of the Rajya Sabha and is nominated by the President to function as such. The leader of House in either house is an important functionary and exercises direct influence on the conduct of business. He can also nominate a deputy leader. He can also nominate a deputy leader of the House. The same functionary in the USA is known as the majority leader. Leader of opposition. In each house of the Parliament, there is a leader of the opposition. The leader of the largest opposition party having not less than 1/10 seats of the total strength of the house is recognized as the leader of the opposition in that house. In a parliamentary system of government, the leader of the opposition has a significant role to play. His main functions are to provide a constructive criticism of the policies of the government and to provide an alternative government. Therefore, the leader of opposition in the Lok Sabha and the Rajya Sabha are accorded statutory recognition in 1977. They are also entitled to the salary allowances and other facilities equivalent to that of a cabinet minister. It was in 1969 that an official leader of the opposition was recognized for the first time. The same functionary in the USA is known as the minority leader. The British political system has a unique institution called the shadow cabinet. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial offices. In this shadow cabinet, almost every member in the ruling cabinet is shadowed by a corresponding member in the opposite cabinet. This shadow cabinet serves as the alternative cabinet if there is change in government. That is why Ivor Jennings described the leader of the opposition as the alternative prime minister. He enjoys the status of a minister and is paid by the government. Whip. Though the offices of the leader of the House and the leader of the opposition are not mentioned in the Constitution of India, they are mentioned in the rules of the House and parliamentary statute respectively. The office of whip, on the other hand, is mentioned neither in the Constitution of India nor in the rules of the House nor in the parliamentary statute. It is based on the conventions of the parliamentary government. Every political party, whether ruling or opposition, has its own whip in the parliament. He is appointed by the political party to serve as an assistant floor leader. He is charged with the responsibility of ensuring the attendance of his party members in large numbers and securing their support in favor of or against a particular issue. He regulates and monitors their behavior in the parliament. The members are supposed to follow the directives given by the whip. Otherwise, disciplinary action can be taken. Sessions of Parliament. Summoning. The President from time to time summons each house of the Parliament to meet, but the maximum gap between the two sessions of the Parliament cannot be more than 6 months. In other words, the Parliament should meet at least twice a year. There are usually 3 sessions in the year: the budget session, the monsoon session, and the winter session. A session of the Parliament is the period spanning between the first sitting of the House and its prorogation or dissolution in the case of the Lok Sabha. During a session, the House meets every day to transact business. The period spanning between the prorogation of a House and its reassembly is a new session is called a recess. Adjournment. A session of the Parliament consists of many meetings. Each meeting of a day consists of 2 sittings, that is, the morning sitting from 11 am to 1 pm and the post-lunch sitting from 2 pm to 6 pm. Adjournment. A sitting of the Parliament consists of many meetings. Each meeting of a day consists of 2 sittings, that is, a morning sitting from 11 am to 1 pm and post-lunch sitting from 2 pm to 6 pm. A sitting of Parliament can be terminated by adjournment or adjournment sine die or prorogation or dissolution in the case of Lok Sabha. An adjournment suspends the work in a sitting or a specified time, which may be hours, days, or weeks. Adjournment sine die. Adjournment sine die means terminating a sitting of the Parliament for an indefinite period. In other words, when the House is adjourned without naming a day for assembly, it is called adjournment sine die. The power of adjournment as well as adjournment sine die lies in the presiding officer of the House. He can also call a sitting of the House before the date or time to which it has been adjourned or at any time after the House has been adjourned sine die. Prorogation. The presiding officer, speaker or chairman declares the House adjourned sine die when the business of a session is completed. Within the next few days, the President issues a notification for prorogation of the session. However, the President can also prorogue the House while in session. Table. A table showing a difference between adjournment and prorogation. So adjournment only terminates a sitting and not a session of the House. Prorogation not only terminates a sitting but also a session of the House. Adjournment is done by presiding officer of the House. Prorogation is done by the President of India. Adjournment does not affect the bill or any other business pending before the House, and the same can be resumed when the House meets again. While the prorogation also does not affect the bill or any other business presiding before the House. However, all the pending notices, other than those for introducing bills, lapse on prorogation, and the fresh notices have to be given for the next session. In Britain, prorogation brings to an end all bills or any other business pending before the House. Dissolution. Rajya Sabha. Rajya Sabha, being a permanent house, is not subject to dissolution. Only the Lok Sabha is subject to dissolution. Unlike the prorogation, a dissolution ends the very life of the existing house, and a new house is constituted after general elections are held. The dissolution of the Lok Sabha may take place in either of 2 ways: automatic dissolution, that is, on the expiry of its tenure of 5 years or the term as extended during the national emergency, or whenever the President decides to dissolve the House, which he is authorized to do so. Once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. When the Lok Sabha is dissolved, all business including bills, motions, resolutions, notices, petitions, and so on pending before it or its committees elapse. They must be reintroduced in the newly constituted Lok Sabha. However, some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the resolution of the Lok Sabha. However, some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the dissolution of the Lok Sabha. The position with respect to the lapsing of bills is as follows. A pending bill in the Lok Sabha lapses, whether originating in the Lok Sabha or transmitted to it by the Rajya Sabha. A bill passed by the Lok Sabha but pending in the Rajya Sabha lapses. A bill not passed by the two houses due to disagreement, and if the president has notified the holding of a joint sitting before the dissolution of the Lok Sabha, does not lapse. A bill pending in the Raj Sabha but not passed by the Lok Sabha does not lapse. A bill passed by both the houses but pending assent for the president does not lapse. A bill passed by both the houses but returned by the president for reconsideration of houses does not lapse. Quorum. Quorum is the minimum number of members required to be present in the house before it can transact any business. It is 1/10 of the total members of the house in each house, including the presiding officer. Okay, including the presiding officer. It means that there must be at least 55 members present in the Lok Sabha and 25 members present in the Rajya Sabha if any business is to be conducted. If there is no quorum during a meeting of the house, it is the duty of the presiding officer either to adjourn the house or to suspend the meeting until there is a quorum. Voting in the house. All matters at any sitting of the either house or joint sitting of both the houses are decided by a majority of votes of the members present and voting, excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution, like impeachment of the president, amendment of the Constitution, removal of the presiding officers of the Parliament, and so on, require special majority, not ordinary majority. The presiding officer of a house does not vote in the first instance but exercises a casting vote in the case of an equality of votes. The proceedings of the house are to be valid irrespective of any unauthorized voting or participation or any vacancy in its membership. Language in the Parliament. The Constitution has declared Hindi and English to be languages for transacting business in the Parliament. However, the presiding officer can permit a permit to address the House in his mother tongue. In both houses, the arrangements are made for simultaneous translations. Though English was to be discontinued as a floor language after the expiration of the 15 years from the commencement of the Constitution, that is, in 1965, the Official Languages Act 1963 allowed English to be continued along with Hindi. Rights of Ministers and Attorney General. In addition to the members of the House, every minister and the Attorney General of India have the right to speak and take part in the proceedings of the other House. Any joint sitting of both the Houses and any committee of the Parliament of which he is a member without being entitled to vote. There are two reasons underlying these constitutional provisions. A minister can participate in the proceedings of a house of which he is not a member. In other words, a minister belonging to a Lok Sabha can participate in the proceedings of the Rajya Sabha and vice versa. And second, a minister who is not a member of the either house can participate in the proceedings of both the houses. It should be noted here that the person can remain a minister for 6 months without being a member of either house of the Parliament. Lame duck session. It refers to the last session of the existing Lok Sabha after a new Lok Sabha has been elected. Those members of the existing Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. Devices of parliamentary proceedings. Question hour. The first hour of every parliamentary sitting is slotted for this. During this time, the members ask questions and the ministers usually give answers. The questions are of three kinds, namely starred, unstarred, and short notice. Starred questions distinguished by an asterisk. Starred questions required an oral answer and hence supplementary questions can follow. And unstarred questions, on the other hand, require a written answer and hence supplementary question cannot follow. A short notice question is one that is asked by giving a notice not less than 10 days. A short notice question is one that is asked by giving a notice of less than 10 days. It is answered orally. 0 hour. Unlike the question hour, the 0 hour is not mentioned in the rules of procedure. Thus, it is an informal device available to the members of the Parliament to raise matters without any prior notice. The 0 hour starts immediately after the question hour and lasts until the agenda for the day, that is regular business of the House, is taken up. In other words, the time gap between the question hour and the agenda is known as 0 hour. It is an Indian innovation in the field of parliamentary procedure and has been in existence since 1962. The 0 hour starts immediately after the question hour and lasts until the agenda for the day is taken up. Motion. No discussion on a matter of general public importance can take place except on the motion made with the consent of the presiding officer. The House expresses its decision or opinions on various issues through the adoption or rejection of the motions moved by either ministers or private members. The motion moved by the members to raise discussions on various matters fall into three principal categories: substantive motion, substitute motion, subsidiary motion. Substantive motion is a self-contained independent proposal dealing with a very important matter like impeachment of the president or removal of chief election commissioner. Substitute motion is a motion that is moved in a substitution of an original motion and proposes an alternative to it. If adopted by the House, it supersedes the original motion. Subsidiary motion is a motion that by itself has no meaning and cannot state the decision of the House without reference to the original motion or proceedings of the House. It is divided into three subcategories. Subsidiary motion is divided into three subcategories: ancillary motion, superseding motion, and amendment. The ancillary motion is used as a regular way of proceeding with various kinds of businesses. Superseding motion is moved in the course of debate on another issue and seeks to supersede that issue. Amendment seeks to modify or substitute only a part of the original motion. Closure motion. Closure motion is a motion moved by a member to cut short the debate on a matter before the House. If the motion is approved by the House, debate is stopped forthwith and the matter is put to vote. There are four kinds of closure motion: simple closure, closure by compartments, kangaroo closure, and guillotine closure. Simple closure. Simple closure is one when a member moves. Simple closure is one when a member moves that the matter having been sufficiently discussed be now put to vote. Closure by compartments. In this case, the clauses of a bill or a lengthy resolution are grouped into parts before the commencement of the debate. The debate covers the part as a whole and the entire part is put to vote. Kangaroo closure. Under this type, only important clauses are taken up for debate and voting, and the intervening clauses are skipped over and taken as passed. Guillotine closure is one when the undiscussed clauses of a will or a resolution are also put to vote along with the discussed ones due to want of time, as the time allotted for the discussion is over. Privilege motion. Privilege motion is concerned with the breach of parliamentary privileges by a minister. Privilege motion is moved by a member when he feels that a member has committed a breach of privilege of the House or one or more of its members by withholding facts of a case or by giving wrong or distorted facts. Its purpose is to censure the concerned minister. Calling attention motion. Calling attention motion is introduced in the Parliament by a member to call the attention of a minister to a matter of urgent public importance to seek an authoritative statement from him on that matter. Like the 0 hour, it is also an Indian innovation in the parliamentary procedure and has been in existence since 1954. However, unlike the 0 hour, it is mentioned in the rules of procedure. Adjournment motion. Adjournment motion is introduced in the Parliament to draw attention of the House to a definite matter of urgent public importance and needs the support of 50 members to be admitted. As it interrupts the normal business of the House, it is regarded as an extraordinary device. Adjournment motion involves an element of censure against the government and hence Rajya Sabha is not permitted to make any use of this device. The discussion on the adjournment motion should last for not less than 2 hours and 30 minutes. The right to move a motion for an adjournment of the business of the House is subject to the following restrictions. It should raise a matter which is definite, factual, urgent, and of public importance. Second, it should not cover more than one matter. Third, it should be restricted to a specific matter of recent occurrence and should not be framed in general terms. Fourth, it should not raise a question of privilege. Fifth, it should not revive discussion on a matter that has been discussed in the same session. Sixth, it should not deal with any matter that is under adjudication by court. Seventh, it should not raise any question that can be raised on a distinct motion. No confidence motion. Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in the office so long as it enjoys the confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no confidence motion. The motion needs the support of 50 members to be admitted. Censure motion. A censure motion is different from a no confidence motion. So there is a difference between a censure motion and no confidence motion. Censure motion should state the reason for its adoption in the Lok Sabha. No confidence motion need not state the reason for its adoption in the Lok Sabha. Censure motion can be moved against an individual minister or a group of ministers or the entire council of ministers. No confidence motion can be moved against the entire council of ministers only. Censure motion is moved for censuring the council of ministers for specific policies and actions. No confidence motion is moved for ascertaining the confidence of Lok Sabha in the council of ministers. Censure motion if censure motion is passed in the Lok Sabha, the council of ministers need not resign from the office. If no confidence motion is passed in the Lok Sabha, the council of ministers must resign from the office. Motion of thanks. The first session after each general election and the first session of every fiscal year is addressed by the president. In this address, the president outlines the policies and programs of the government in the preceding year and the ensuing year. This address of the president, which corresponds to the speech from the throne in the Britain, is discussed in both the houses of the parliament on the motion called the motion of thanks. At the end of the discussion, the motion is put to vote. This portion must be passed in the house, otherwise it amounts to defeat of the government. This inaugural speech of the president is an occasion available to the members of the parliament to raise discussions and debates, to examine and criticize the government and administration for its lapses and failures. No day yet named motion is a motion that has been admitted by the speaker but no date has been fixed for its discussion. The speaker after considering the state of the business in the house, the speaker after considering the state of business in the house and in consultation with the leader of the house or on the recommendation of the business advisory committee allots a day or days or part of a day for the discussion of such a motion. Point of order. A member can raise a point of order when the proceedings of the house do not follow the normal rules of procedure. A point of order should relate to the interpretation or enforcement of the rules of the house or such articles of the constitution that regulate the business of the house and should raise a question that is within the cognizance of the speaker. It is usually raised by an opposition member in order to control the government. It is an extraordinary device and it suspends the proceeding before the house. No debate is allowed on a point of order. Half an hour discussion. It is meant for discussion of matter of sufficient public importance which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. The speaker can allot 3 days in a week for such discussions. There is no formal motion for voting before the house. Short duration discussion. Short duration discussion is also known as 2-hour discussion, as the time allotted for such a discussion should not exceed 2 hours. The members of the parliament can raise such discussions on a matter of urgent public importance. The speaker can allot 2 days in a week for such discussions. There is neither a formal motion before the house nor voting. This device has been in existence since 1953. Special attention. A matter which is not a point of order or which cannot be raised during the question hour, half an hour discussion, short duration discussion or under adjournment motion. Calling attention notice or under any rule of the house can be raised under the special mention of the Rajya Sabha. Its equivalent procedural device in the Lok Sabha is known as the notice mentioned under article notice under rule 377. Resolutions. The members can move resolutions to draw the attention of the house or the government to matters of general public interest. The discussion of a resolution is strictly relevant to and within the scope of the resolution. A member who has moved a resolution or amendment to a resolution cannot withdraw the same except by the leave of the house. Resolutions are classified into 3 categories: private members resolution, government resolution and statutory resolution. So private members resolution is one that is moved by a private member other than a minister. It is discussed only on alternate Fridays and in the afternoon sitting. Government resolution is one that is moved by a minister It can be taken up by any day from Monday to Thursday. Statutory resolution, it can be moved either by a private member or a minister. It is so called because it is always tabled in pursuance of the provision of a constitution, of a provision in the constitution or an act of the parliament. Resolutions are different from motions in the following respects. All resolutions come in the category of substantive motions. That is to say, every resolution is a particular type of motion. All motions need not necessarily be substantive. Further, all motions are not necessarily put to vote of the House, whereas all the resolutions are required to be voted upon. Youth Parliament. The scheme of Youth Parliament was started on the recommendations of the 4th All India Whips Commission. The scheme of Youth Parliament was started on the recommendation of 4th All India Whips Conference. Its objectives are to acquaint the younger generation with practices and procedures of the Parliament, to imbibe the spirit of discipline and tolerance, cultivating the character in the minds of youth, and to inculcate in the student community the basic values of democracy, and to enable them to acquire a proper perspective on the functioning of democratic institutions. The Ministry of Parliamentary Affairs provides necessary training and encouragement to the states in introducing the scheme. Legislative procedure in the Parliament. The legislative procedure is identical in both the houses of the Parliament. Every bill has to pass through the same stages in each house. A bill is a proposal for legislation, and it becomes an act or law when duly enacted. Bills introduced in the Parliament are of two kinds: public bills and private bills. Private bills, also known as public bills and private bills. Okay. Though both are governed by the same general procedure and pass through the same stages in the House, they differ in the various aspects as shown in the table. So, public bill and private bill. So, public bill is introduced in the Parliament by a minister, jabki private bill is introduced by any member of the Parliament other than a minister. Public bill reflects of the policies of the government ruling party. Private bill reflects the stand of opposition party on public matter. Public bill has greater chance to be approved by the Parliament. Private bill has the lesser chance to be approved by the Parliament. Public bill's rejection by the House amounts to the expression of want of parliamentary confidence in the government and may lead to its resignation. Private bill's resignation on the House has no implication on the parliamentary confidence in the government or its resignation. Public bill's introduction in the House requires 7 days notice. Private bill's introduction in the House requires 1 month's notice. Public bills is drafted by the concerned department in the consultation with the law department. Private bill's drafting is the responsibility of the member concerned. So the bills introduced in the Parliament can also be classified into 4 categories: ordinary bills, money bills, finance bills, and constitution amendment bills. So the ordinary bills, which are concerned with any matter other than the financial subjects. Money bills, which are concerned with the financial matters like the taxation, public expenditure, etc. Financial bills, which are also concerned with the financial matters but are different from the money bills. And constitution amendment bills, which are concerned with the amendment of the provisions of the constitution. The constitution has laid down separate procedure for the enactment of all the 4 types of the bills. The procedures with regard to ordinary bills, money bills, and financial bills are explained here. Ordinary bills. Every ordinary bill has to pass through the following 5 stages of the Parliament before it finds a place on the statute book. First reading. An ordinary bill can be introduced in either house of the Parliament. Such a bill can be introduced by a minister or by an other member. The member who wants to introduce the bill has to ask for the leave of the House. When the House grants leave to introduce the bill, the mover of the bill introduces it by reading its title and objectives. No discussion on the bill takes place in this stage. Later, the bill is published in the Gazette of India. If a bill is published in the Gazette before its introduction, the leave of the House to introduce the bill is not necessary. The introduction of the bill and its publication in the Gazette constitute the first reading of the House. Second reading. During this stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. During second stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. Hence, it forms the most important stage in the enactment of a bill. In fact, the second stage involves three more sub-stages, namely the stage of general discussion, committee stage, and consideration stage. In stage of general discussion, the printed copies of the bills are distributed to all members. The principles of the bill and its provisions are discussed generally, but the details of the bill are not discussed. At this stage, the House can take any one of the following four actions. It may take the bill into consideration immediately or on some other fixed date. It may refer the bill to a select committee for the House. It may refer the bill to a joint committee of the two houses, and it may circulate the bill to elicit public opinion. A select committee consists of members of the House where the bill has originated, and a joint committee consists of members of both houses of the Parliament. Next is the B is the committee stage. The usual practice is to refer the bill to a select committee of the House. This committee examines the bill thoroughly and in detail, clause by clause. It can also amend its provisions, but without altering the principles underlying it. After completing the scrutiny and discussion, the committee reports the bill back to the House. Consideration stage. The House after receiving the bill from the select committee considers the provision of the bill clause by clause. Each clause is discussed and voted upon separately. The members can also move amendments, and if accepted, they become part of a bill. Third reading. At third reading stage, the debate is confined to the acceptance or rejection of the bill as a whole, and no amendments are allowed. As the general principle underlying the bill have already been scrutinized during the stage of the second reading, if the majority of the members present and voting accept the bill is regarded as passed by the House. Thereafter, the bill is authenticated by the presiding officer of the House and transmitted to the second House for consideration and approval. A bill is deemed to have been passed by the Parliament only when both the houses have agreed to it, either with or without amendments. Bill in the second House. In the second House also, the bill passes through all the three stages, that is the first reading, second reading, and third reading. There are four alternatives before this House. It may pass the bill as sent by the first House, that is without amendments. It may pass the bill with amendments and return it to the first House for reconsideration. It may reject the bill altogether, and it may not take any action and thus keep the bill pending. If the second House passes the bill without any amendments, or the first House accepts the amendments suggested by the second House, the bill is deemed to have been passed by both houses of the Parliament, and the same is sent to the President for his assent. On the other hand, if the House rejects the amendments suggested by the second House, or the second House rejects the bill altogether, or the second House does not take any action for the 6 months, a deadlock is deemed to have been taken place. To resolve such a deadlock, the President can summon a joint sitting of the two houses. If the majority of members present and voting in the two houses in the joint sitting approves the bill is deemed to have been passed by both the houses. Assent of the President. Every bill after being passed by both the houses of the Parliament, either singly or at the joint sitting, is presented to the President for his assent. There are three alternatives before the President. He may give his assent to the bill, or he may withhold his assent to the bill, or he may return the bill for reconsideration of the houses. If the President gives his assent to the bill becomes an act and is placed on the statute book. If the President withholds his assent to the bill, it ends and does not become an act. If the President returns the bill for reconsideration, and if it is passed by both the houses again, with or without amendments, and presented to the President for his assent, the President must give his assent to the bill. Thus, the President enjoys only a suspensive veto. Money bills. Article 110 of the Constitution deals with the definition of money bills. It states that a bill is deemed to be a money bill if it contains only the provisions dealing with all or any of the following matters. First, the imposition, abolition, remission, alteration, or regulation of any tax. Second, the regulation of borrowing of money by Union government. Third, the custody of Consolidated Fund of India or the Contingency Fund of India, the payment of monies into or the withdrawal of the money from any such fund. Fourth, the appropriation of money out of the Consolidated Fund of India. Fifth, the declaration of any expenditure charged on the Consolidated Fund of India or increasing the amount of any such expenditure. Sixth, the receipt of money of House of the Consolidated Fund of India or the public account of India or the custody of issue of such money or the audit of accounts of the union or of a state. Any matter incidental of any of the matters specified above. However, a bill is not to be deemed to be a money bill if however, a bill is not to be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties or the demand or payment of fees or licenses, fees for licenses or fees for services rendered or the imposition, abolition, remission, alteration or regulation of fine tax by any local authority or body for local purposes. If any question rises whether a bill is a money bill or not, the decision of the Speaker of the Lok Sabha is final. His decision in this regard cannot be questioned in any court of the law or in either house of the parliament or even the president. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the president for assent, the Speaker endorses it as a money bill. The Constitution lays down a special procedure for the passing of the money bills in the Parliament. A money bill can only be introduced in the Lok Sabha, and that too on the recommendation of the President. Every such bill is considered to be a government bill and can be introduced only by a minister. After the money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its consideration. The Rajya Sabha has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make the recommendations. It must return the bill to the Lok Sabha within 14 days with or without amendments. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accepts any recommendations, the bill is then deemed to have been passed by both the houses in the modified form. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Lok Sabha without any change. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the houses in the form originally passed by the Lok Sabha. Thus, the Lok Sabha has more powers than the Rajya Sabha with regard to the money bill. On the other hand, both the houses have equal powers with regard to the ordinary bill. Finally, when a money bill is presented to the President, he may either give his assent to the bill or withhold his assent to the bill, but cannot return the bill for the consideration of the President. Normally, the President gives his assent to a money bill as it is introduced in the Parliament with his prior permission. Table shows the difference between the procedures of enactment of ordinary and bills and money bills. So, ordinary bills and money bills. Ordinary bill can be introduced either in the Lok Sabha or the Rajya Sabha. Money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. Ordinary bill can be introduced either by a minister or by a private member. Money bill can be introduced only by a minister. Ordinary bill is introduced without the recommendation of the President. Money bill can be introduced only on the recommendations of the President. Ordinary bill can be amended or rejected by the Rajya Sabha. Money bill cannot be amended or rejected by the Rajya Sabha. The Rajya Sabha should return the bill with or without recommendations, which may be accepted or rejected by the Lok Sabha. Ordinary bill can be detained by the Rajya Sabha for a maximum period of 6 months. Money bill can be detained by the Rajya Sabha for a maximum period of 14 days only. Ordinary bill does not require the certification of the Speaker when transmission to the Lok Sabha if it has originated in the Lok Sabha. Money bill requires the certification of the Speaker when transmitted to the Rajya Sabha. Ordinary bill is sent for the President's assent only after being approved by both the houses. In case of a deadlock due to a disagreement between the two houses, a joint sitting of two houses can be summoned by the President to resolve the deadlock. Money bill is sent for the President's assent even if it is approved by only Lok Sabha. There is no chance of any disagreement between the two houses, and hence there is no provision for a joint sitting of the both houses in this regard. Ordinary bill's defeat in the Lok Sabha may lead to the resignation of the government if it is introduced by a minister. Money bill's defeat in the Lok Sabha leads to the resignation of the government. Ordinary bill can be rejected, approved, or returned for reconsideration by the President. Money bill can be rejected or approved but cannot be returned for the reconsideration of the President. Financial bills. Financial bills are those bills that deal with the fiscal matters, that is, revenue or expenditure. However, the Constitution uses the term financial bills in the technical sense. Financial bills are of three types: money bills, financial bills 1, and financial bills 2. Money bills under Article 110, financial bills 1 under Article 117 Clause 1, and financial bills 2 under Article 117 Clause 3. 117 Financial bills 1 under Article 117 Clause 1, and financial bills 2 under Article 117 Clause 3. This classification implies that money bills are simply a species of financial bills. Hence, all money bills are financial bills, but all financial bills, but all financial bills are not money bills. Only those financial bills are money bills which contain exclusively those matters which are mentioned in the Article 110 of the Constitution. These are also certified by the Speaker of the Lok Sabha as money bills. The financial bills 1 and 2, on the other hand, have been dealt within Article 117 of the Constitution. Financial bills 1. A financial bill 1 is a bill that contains not only any or all the matters mentioned in the Article 110, but also other matters of the general legislation. For instance, a bill that contains a borrowing clause but does not exclusively deal with borrowing. In two respects, the financial bill 1 is similar to the money bill. Both of them can be introduced only in the Lok Sabha and not in the Rajya Sabha. Both of them can be introduced only on the recommendation of the President. In all other respects, a financial bill 1 is governed by the same legislative procedure applicable to any ordinary bill. Hence, it can be either rejected or amended by the Rajya Sabha, except that an amendment other than for the reduction or abolition of a tax cannot be moved in either house without the recommendation of the President. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for the reconsideration of the President. Financial Bills 2. The Financial Bill 2 contains provisions involving expenditure from the Consolidated Fund of India, but does not include any of the matters mentioned in the Article 110. It is treated as an ordinary bill, and in all respects, it is governed by the same legislative procedure which is applicable to an ordinary bill. The only special feature of this bill is that it cannot be passed by either house of the Parliament unless the President has recommended to that house the consideration of the bill. Hence, the Financial Bill 2 can be introduced in either house of the Parliament, and recommendation of the President is not necessary for its introduction. It can be either rejected or amended by either house of the Parliament. In case of disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill, or return the bill for reconsideration of the houses. Joint sitting of two houses. Joint sitting is an extraordinary machinery provided by the Constitution to resolve a deadlock between the two houses over the passage of the bill. A deadlock is deemed to have been passed under any one of the following three situations after a bill has been passed by one house and transmitted to the other house: if the bill is rejected by the other house, if the houses have finally disagreed as to the amendments to be made in the bill, or if more than 6 months have elapsed from the date of the receipt of the bill by the other house without the bill being passed by it. In the above three situations, the President can summon both the houses to meet in a joint sitting for the purpose of deliberating and voting on this bill. It must be noted here that the provision of joint sitting is applicable to ordinary bills or financial bills only, and not to the money bills or the constitutional amendment bills. In the case of money bill, the Lok Sabha has overriding powers, while a constitutional amendment bill must be passed by each house separately. In reckoning the period of 6 months, no account can be taken for any period during which the other house to which the bill has been sent is prorogued or adjourned for motion for more than 4 consecutive days. In reckoning the period of 6 months, in reckoning the period of 6 months, No account can be taken for any period during which the other house is prorogued or adjourned for more than 4 consecutive days. If the bill under dispute has already lapsed due to the resolution of the Lok Sabha, no joint sitting can be summoned. But the joint sitting can be held if the Lok Sabha is dissolved after the President has notified his intention to summon such a sitting, as the bill does not lapse in this case. After the President notifies his intention to summon a joint sitting of the two houses, none of the houses can proceed further with the bill. The Speaker of the Lok Sabha presides over a joint sitting of the two houses and the Deputy Speaker in his absence. If the Deputy Speaker is also absent from a joint sitting, the Deputy Chairman of the Rajya Sabha presides. If he is also absent, such other person as may be determined by the members present at the joint sitting presides over the meeting. It is clear that the Chairman of the Rajya Sabha does not preside over a joint sitting, as he is not a member of either house of the Parliament. The quorum to constitute a joint sitting is 1/10 of the total number of the members of the two houses. The joint sitting is governed by the rules of procedures of the Lok Sabha and not of the Rajya Sabha. If a bill in dispute is passed by a majority of the total number of members of both the houses present and voting in the joint sitting, the bill is deemed to have been passed by both the houses of the Parliament. Normally, the Lok Sabha with greater number wins the battle in the joint sitting. The Constitution has specified that at a joint sitting, new amendments to the bill cannot be proposed except in two cases: those amendments that have caused final disagreement between the houses, and those agreements that might have become necessary due to the delay in the passage of the bill. Since 1950, the provision regarding the joint sitting of the two houses has been invoked only thrice. The bills have been passed at joint sittings are Dowry Prohibition Bill 1960, the Banking Service Commission Repeal Bill 1977, and the Prevention of Terrorism Bill 2002. Budget in Parliament. The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been mentioned in the Constitution. It is the popular name of the annual financial statement that has been dealt with within Article 112 of the Constitution. 112 of the Constitution. The budget is a statement of the estimated receipts and expenditure of the Government of India in a financial year, which begins on 1st April and ends on 31st March of the year. In addition to the estimates of the receipts and expenditure, the budget contains certain other elements. Overall, the budget contains the following: estimates of revenue and capital receipts, ways and means to raise the revenue, estimates of expenditure, details of actual receipts and expenditure of the closing financial year and the reasons for any deficit or surplus in that year, an economic and financial policy of the coming year, that is, taxation proposals, prospects of revenue, spending program and introduction of new schemes projects. The Government of India has two budgets, namely अब तो डाना विविध हो गया, अब तो सिंगल ही है. The railway budget was separated from the general budget in 1921 on the recommendations of the Ackworth Committee. The reasons or objectives of this separation are as follows: to introduce flexibility in railway finance, to facilitate a business approach to the railway policy, to secure stability of the general revenues by providing an assured annual contribution from the railway revenues, to enable the railways to keep their profits for their own development after paying a fixed annual contribution to the general revenues. Constitutional provisions. The Constitution of India contains the following provisions with regard to the enactment of the budget. Article 112. The President shall, in respect of every financial year, cause to be laid before both the Houses of the Parliament a statement of estimated receipts and expenditure of the Government of India for that year. Article 113. No demand for grant shall be made except on the recommendation of the President. Next, Article 114. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by the law. Article 117. No money bill imposing tax shall be introduced in the Parliament except on the recommendation of the President, and such a bill shall not be introduced in the Rajya Sabha. Next, Article 265. No tax shall be levied or collected except by the authority of the law. Article 265. No tax shall be levied or collected except by the authority of the law. Next, again Article 117. Parliament can reduce or abolish a tax but cannot increase it. The Constitution has also defined the relative roles or positions of both the houses of the Parliament with regard to the enactment of the budget in the following way. A money bill or finance bill dealing with the taxation cannot be introduced in the Rajya Sabha. It must be introduced only in the Lok Sabha. The Rajya Sabha has no power to vote on the demand for the grant. It is the exclusive privilege of the Lok Sabha. The Rajya Sabha should return the money bill or finance bill to the Lok Sabha within 14 days. The Lok Sabha can either accept or reject the recommendations made by the Rajya Sabha in this regard. The estimates of expenditure embodied in the budget shall show separately the expenditure charged on the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. The budget shall distinguish expenditure on the revenue account from other expenditures. Article 112. Article 112. The budget shall distinguish expenditure on the revenue account from other expenditure. Article 112. The budget shall distinguish expenditure on revenue account from other expenditure. Charge expenditure. The budget consists of two types of expenditure: the expenditure charged upon the Consolidated Fund of India, and the expenditure made from the expenditure made from the Consolidated Fund of India. The charge expenditure is non-votable by the Parliament. That is, it can only be discussed by the Parliament, while the other type has to be voted by the Parliament. The list of the charge expenditure is as followed: emoluments and allowances of the President and other expenditure relating to his office; salaries and allowances of the Chairman and the Deputy Chairman of the Rajya Sabha and the Speaker and Deputy Speaker of the Lok Sabha; salaries, allowances and pensions of the judges of the Supreme Court; pensions of the judges of the High Court; salaries, allowances and pensions of the CAG; salaries, allowances and pensions of the Chairman and members of the UPSC; administrative expenses of the Supreme Court, the office of the CAG of India and the UPSC Commission, including the salaries, allowances and pensions of the persons serving in these offices; the debt charges for which the Government of India is liable, including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt; any sum required to satisfy any judgment, decree or award of any court or arbitral tribunal; any other expenditure declared by the Parliament to be so charged. Stages in enactment. The budget goes through the following 6 stages in the Parliament. First, presentation of the budget. Second, general discussion. Third, scrutiny by departmental committees. Fourth, voting on demands for grants. Fifth, passing of appropriation bill. And sixth, passing of the finance bill. So the first, presentation of the budget. The budget is presented in two parts. The budget is presented in the Lok Sabha. The introduction. The finance minister presents the general budget with a speech known as the budget speech. At the end of the speech in the Lok Sabha, the budget is laid before the Rajya Sabha. At the end of the speech in the Lok Sabha, the budget is laid before the Rajya Sabha, which can only discuss it and has no power to vote on the demands for grants. Second stage, general discussion. General discussion on the budget begins a few days after its presentation. It takes place in both the houses of the Parliament and lasts usually for 3 to 4 days. During this stage, the Lok Sabha can discuss the budget as a whole or on any question of principle involved therein, but no cut motion can be moved, nor can the budget be submitted to the vote of the House. The finance minister has the general right of reply at the end of the discussion. Third stage, scrutiny by departmental committees. After the general discussion on the budget is over, the houses are adjourned for about 3 to 4 weeks. During this gap, the 24 departmental standing committees of the Parliament examine and discuss in detail the demands for grant of the concerned ministers and prepare reports on them. These reports are submitted to both the houses of the Parliament for consideration. The standing committee system established is 1993 and expanded in 2004. The standing committee system established in 1993 makes parliamentary financial control over ministries much more detailed, close, in-depth and comprehensive. Fourth stage, voting on demands for grant. In the light of the reports of the departmental standing committees, the Lok Sabha takes up votings on demands for the grants. The demands are presented ministry-wise. A demand becomes a grant after it has been duly voted. 2 points should be noted in this context. 1. The voting of the demand for grants is the exclusive privilege of the Lok Sabha, that is, the Rajya Sabha has no power of voting the demands. And second, the voting is confined to the votable part of the budget. The expenditure charged on the Consolidated Fund of India is not subject to the vote. It can only be discussed. While the general budget has a total of 109 demands, 103 for civil expenditure and 6 for defense expenditure. The railway budget had 32 demands. Each demand is voted separately by the Lok Sabha. During this stage, the members of the parliament can discuss the details of the budget. They can also move motions to reduce any demand for the grant. Such motions are called cut motions, which are of 3 types. Policy cut motion. Policy cut motion represents the disapproval of the policy underlying the demand. Policy cut motion states that the amount of the demand be reduced to ₹1. The members can only advocate an alternative policy. B. Economic cut motion. Economic cut motion represents the economy that can be affected by the proposed expenditure. Economic cut motion states that the amount of the demand be reduced by a specified amount, which may be either a lump sum reduction in the demand or omission or reduction of any item in the demand. Token cut motion. Token cut motion, it ventilates a specific grievance that is within the sphere of responsibility of the Government of India. Token cut motion states that the amount of the demand be reduced by ₹100. A cut motion to be admissible must satisfy the following conditions. It should relate to one demand only. It should be clearly expressed as and should not contain arguments or defamatory statements. It should be confined to one specific matter. It should not make suggestions for the amendment or repeal of existing laws. It should not refer to a matter that is not primarily the concern of the Union government. It should not relate to the expenditure charged on the Consolidated Fund of India. It should not relate to the matter that is under adjudication by a court. It should not raise a question of privilege. It should not revive discussion on a matter on which a decision has been taken in the same session. It should not relate to a trivial matter. The significance of a cut motion lies in facilitating the initiation of concentrated discussion on specific demand for grant, and upholding the principle of responsible government by proving the activities of the government. However, the cut motion does not have much utility in practice. They are only moved and discussed in the House, but not passed as the government enjoys majority support. Their passage by the Lok Sabha amounts to the expression of want of parliamentary confidence in the government and may lead to its resignation. In total, 26 days are allotted for the voting of demands. On the last day, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. Stage 5. Passing of Appropriation Bill. The Constitution states that no money shall be drawn from the Consolidated Fund of India except under the appropriation made by the law. Accordingly, the Appropriation Bill is introduced to provide for the appropriation out of the Consolidated Fund of India on money required to meet the grants voted by the Lok Sabha. Money required to meet the grants voted by the Lok Sabha. The expenditure charged on the Consolidated Fund of India. No such amendment can be proposed to the appropriation bill in either house of the parliament that will have the effect of varying the amount or altering the destination of any grant voted or varying the amount of any expenditure charged on the Consolidated Fund of India. The appropriation bill becomes the appropriation act after it is assented to by the President. This act authorizes or legalizes the payments from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India till the enactment of the appropriation bill. This takes time and usually goes on till the end of April. But the government needs money to carry on its normal activities after 31 March, the end of the financial year. To overcome this functional difficulty, the Constitution has authorized the Lok Sabha to make any grant in advance in respect to the estimated expenditure for a part of the financial year pending the completion of the voting of the demands for the grants and the enactment of the appropriation bill. This provision is known as the vote on account. It is passed or granted after the general discussion on the budget is over. It is generally granted for 2 months for an amount equivalent to the 1/6 of the total estimation. Stage 6. Passing of Financial Bill. or Finance Bill. The Finance Bill is introduced to give effect to the financial proposals of the Government of India for the following year. It is subjected to all the conditions applicable to a money bill. Unlike the appropriation bill, the amendments seeking to reject or reduce a tax can be moved in the case of Finance Bill. According to the Provisional Collection of Taxes Act of 1931, the Finance Bill must be enacted, that is passed by the Parliament and assented to by the President within 75 days. The Finance Act legalizes the income side of the budget and completes the process of enactment of the budget. Other grants. In addition to the budget that contains the ordinary estimates of the income and expenditure of for other financial years, the various other grants are made by the Parliament under extraordinary or special circumstances. Supplementary grant. Supplementary grant is granted when the amount authorized by the Parliament through the Appropriation Act for a particular service for the current financial year is found to be insufficient for that year. Additional grant is granted when the need has arisen during the current financial year for additional expenditure upon some new service contemplated in the budget for that year. Excess grant is granted when money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. Excess grant is voted by the Lok Sabha after the financial year. Before the demands for excess grants are submitted to the Lok Sabha for voting, excess grant must be approved by the Public Account Committee of the Parliament. Vote of credit. Vote of credit is granted for meeting an unexpected demand upon the resources of India. When on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in the budget. Hence, it is like a blank check given to the executive by the Lok Sabha. Exceptional grant. Exceptional grant is granted for a special purpose and forms no part of the current service of any financial year. Token grant. Token grant is granted when funds to meet the proposed expenditure on a new service can be made available by reappropriation. A demand for a grant of a token sum rupees or token sum of rupees 1 is submitted to the vote of the Lok Sabha, and if assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve any additional expenditure. Supplementary, additional, excess and exceptional grants and vote of credit are regulated by the same procedure which is applicable in the case of a regular budget. Funds. The Constitution of India provides for the following three kinds of funds for the central government: the Consolidated Fund of India, Article 266, the Public Accounts of India, Article 266, and the Contingency Fund of India, Article 267. The Consolidated Fund of India under Article 266. The Consolidated Fund of India is a fund to which all the receipts are credited. To which all the receipts are credited. To which all the receipts are credited and all the payments are debited. In other words, all revenues received by the Government of India, all loans raised by the government by the issue of treasury bills, loans or ways and means of advances, and all money received by the government in payment of loans from the Consolidated Fund of India. All the legally authorized payments on the behalf of the Government of India are made out of this fund. No money out of this fund, that is Consolidated Fund of India, can be appropriated or issued or drawn except in accordance with the parliamentary law. Next is the Public Account of India under Article 266. All other public money other than those which is credited to the Consolidated Fund of India received by or on behalf of the Government of India shall be credited to the public accounts of India. This includes Provident Fund deposited, judicial deposits, saving bank deposits, departmental deposits, remittances, and so on. This account is operated by executive action. That is, the payment from this account can be made without parliamentary appropriation. Such payments are mostly in nature of the banking transaction. Contingency Fund of India under Article 267. The Constitution authorizes the Parliament to establish a Contingency Fund of India into which amounts determined by the law are paid from time to time. Accordingly, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President, and he can make advances out of it to meet the unforeseen expenditure pending its authorization by the Parliament. The fund is held by the Finance Secretary on behalf of the President. Like the Public Account of India, it is also operated by the executive action. Multifunctional role of Parliament. In the Indian politico-administrative system, the Parliament occupies a central position and has a multifunctional role. Parliament enjoys extensive powers, and performs a variety of functions towards the fulfillment of its constitutionally expected roles. Its powers and functions can be classified under the following heads: legislative powers and functions, executive powers and functions, financial powers and functions, constituent powers and functions, judicial powers and functions, electoral powers and functions, and other powers and functions. So first is the legislative powers and functions. The primary function of the Parliament is to make laws for the governance of the country. It has the exclusive power to make laws on the subjects enumerated in the Union list, which at present has 100 subjects, originally 97 subjects, and on the residuary subjects, that is subjects not enumerated in any of the three lists. With regard to the concurrent list, which has at present 52 subjects, originally 47 subjects, the Parliament has overriding power, that is, the law of the Parliament prevails over the law of the state legislature in the case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list, which at present has 61 subjects, originally 66 subjects, under the following 5 abnormal circumstances. When Rajya Sabha passes a resolution to that effect, when a proclamation of national emergency is in operation, when two or more states make a joint request to the Parliament, when necessary to give effect to international agreements, treaties, and conventions, when President rule is in operation in the state. All the ordinances issued by the President during the recess of the Parliament must be approved by the Parliament within 6 weeks after its reassembly. An ordinance becomes inoperative if it is not approved by the Parliament within that period. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as the delegated legislation or the executive legislation or the subordinate legislation. Such rules and regulations are placed before the Parliament for its examination. Second power and function, executive power and function. The Constitution of India established a parliamentary form of government in which the executive is responsible to the Parliament for its policies and acts. Hence, the Parliament exercises control over the executive through question hour, 0 hour, half hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion, and other discussions. It also supervises the activities of the executive within the help of its committees, like Committee on Government Assurance, Committee on Subordinate Legislation, Committee on Petitions, etc. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. As a part of collective responsibility, there is individual responsibility, that is, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from the office by the Lok Sabha by passing a no confidence motion. The Lok Sabha can also express lack of confidence in the government in the following ways: by not passing a motion of thanks on the President's inaugural address; B. by rejecting a money bill; C. by passing a censure motion or an adjournment motion; D. by defeating the government on a vital issue; E. by passing a cut motion. Therefore, the first function of the Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general elections. Financial powers and third point, financial powers and functions. No tax can be levied or collected, and no expenditure can be incurred by the executive except under the authority and with the approval of the Parliament. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipts and expenditure of the government for the ensuing financial year. The Parliament also scrutinizes government spending and financial performance with the help of its financial committees. These include Public Accounts Committee, Estimates Committee, and Committee on Public Undertakings. They bring out the cases of illegal, irregular, unauthorized, improper usage and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in two stages: budgetary control and post budgetary control. In budgetary control, that is control before the appropriation of grants through the enactment of the budget, and post budgetary control, that is control after the appropriation of the grants through the three financial committees. The budget is based on the principles of annuality. That is, the parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is known as the rule of the lapse. It facilitates effective financial control by the parliament, as no reserve funds can be built without its authorization. However, the observance of this rule leads to a heavy rush of expenditure towards the close of the financial year. This is properly called as the March rush. Fourth point: constituent powers and functions. Constituent powers and functions. The parliament is vested with the parliament is vested with the power. The parliament is vested with the powers to amend the constitution by way of addition, variation, or repeal of any provision. The major part of the constitution can be amended by the parliament with special majority, that is, a majority of the total members of each house, and a majority of not less than 2/3 of the members present and voting in each house. Majority means that is more than 50%. Some other provisions of the constitution can be amended by the parliament with simple majority, that is, a majority of the members present and voting in each house of the parliament. Only a few provisions of the constitution can be amended by the parliament by special majority and with the consent of at least half of the state's legislature by simple majority. However, the power to initiate the process of the amendment of the constitution in all three cases lies exclusively in the hands of the parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the parliament for the creation or abolition of a legislative council in the state. Based on the resolution, the parliament makes an act for amending the constitution to that effect. To sum up, the parliament can amend the constitution in 3 bits: by simple majority, by special majority, and by special majority, but with the consent of the half of all the states legislature. The constituent powers of the parliament is not unlimited. It is subject to the basic structure of the constitution. In other words, the parliament can amend any provision of the constitution except the basic features of the constitution. This was ruled by the Supreme Court in the Keshwananda Bharati case 1973 and reaffirmed the Minerva Mills case in 1980. Fifth point: judicial powers and functions. The judicial powers and functions of the parliament include the following: it can impeach the president for the violation of the constitution, it can remove the vice president from his office, it can recommend the removal of the judges, including the chief justice of the Supreme Court and the high courts, chief election commissioner, comptroller, and auditor general to the president. It can punish its members or outsiders for the breach of its privileges or its contempt. Sixth point: electoral powers and functions. The parliament participates in the elections of the president along with the state legislative assemblies and elects the vice president. The Lok Sabha elects its speaker and deputy speaker, while the Rajya Sabha elects its deputy chairman. The parliament is also authorized to make laws to regulate the elections to the offices of the president and vice president, to both the houses of the parliament and to both the houses of the state legislature. Accordingly, Parliament enacted the Presidential and Vice Presidential Election Act 1952, Representation of People Act 1950 and 1951, etc. Seventh point: other powers and functions. The various other powers and functions of the Parliament include: it serves as the highest deliberative body in the country. It discusses various issues of national and international significance. Parliament approves all the types of the emergencies, national, state, and financial, proclaimed by the President. Parliament can create or abolish the state legislative council on the recommendation of the concerned state legislative assemblies. Parliament can increase or decrease the area, alter the boundaries, and change the names of the states of the Indian Union. Parliament can regulate the organization and jurisdiction of the Supreme Court and High Courts and can establish a common High Court for 2 or more states. Ineffectiveness of parliamentary control. The parliamentary control over the government and administration in India is more theoretical than the practical. In reality, the control is not as effective as it ought to be. The following factors are responsible for this. The parliament has neither time nor expertise to control the administration, which has grown in volume as well as complexity. Parliament's financial control is hindered by the technical nature of the demands for grants. The parliamentarians, being laymen, cannot understand them properly and fully. The legislative leadership lies with the executive, and it plays a significant role in the formulating policies. The very size of the parliament is too large and, and unmanageable to be effective. The majority support enjoyed by the executive in the parliament reduces the possibility of effective criticism. The financial committees, like the Public Accounts Committee, examines the public expenditure after it has been incurred by the executive. Thus, they do the post-mortem work. The increased recourse to guillotine reduce the scope of financial control. The growth of delegated legislation has reduced the role of Parliament in making detailed laws and has increased the powers of the bureaucracy. The frequent promulgation of ordinances by the President dilutes the Parliament's power of legislation. The Parliament's control is sporadic, general, and mostly political in nature. Lack of strong and steady opposition in the Parliament and a setback in the parliamentary behavior and ethics have also contributed to the ineffectiveness of the legislative control over administration in India. Position of the Rajya Sabha. The constitutional position of the Rajya Sabha as compared with the Lok Sabha can be studied from the three angles: where Rajya Sabha is equal to the Lok Sabha, where Rajya Sabha is unequal to the Lok Sabha, where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. So the equal status with the Lok Sabha. First, introduction and passage of ordinary bills. Introduction and passage of constitutional amendment bills. Introduction and passage of financial bills involving expenditure from the Consolidated Fund of India. Election and impeachment of the President. Election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of the President. He is removed by a resolution passed by the Rajya Sabha by a special majority and agreed to by the Lok Sabha by a simple majority. Making recommendations to the President for the removal of the Chief Justice and judges of the Supreme Court, High Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General. Approval of ordinances issued by the President. Approval of proclamation of all the three types of emergencies by the President. Selection of ministers, including the Prime Minister. Under the Constitution, the ministers include the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. Consideration of the reports of the constitutional bodies like the Finance Commission, UPSC, CAG, etc. Enlargement of the jurisdiction of the Supreme Court and UPSC. Unequal status with the Lok Sabha. A money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. Rajya Sabha cannot amend or reject a money bill. It should return the bill to the Lok Sabha within 14 days, either with the recommendations or without recommendations. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by the two houses. A finance bill not containing solely the matters of the Article 110 also can be introduced only in the Lok Sabha and not in the Rajya Sabha. But with regard to its passage, both the houses have equal powers. The final powers to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. The Speaker of the Lok Sabha presides over the joint sitting of both the houses of the Parliament. The Lok Sabha with greater number wins the battle in a joint sitting, except when the combined strength of the ruling party in the both houses is less than that of the opposition parties. Rajya Sabha can only discuss the budget, but cannot vote on the demands for the grants, which is the exclusive privilege of the Lok Sabha. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. The Rajya Sabha cannot remove the Council of Ministers by passing no confidence motion. This is because the Council of Ministers is responsible. This is because the Council of Ministers is collectively responsible only to the Lok Sabha. But the Rajya Sabha can discuss and criticize the policies and activities of the government. Special powers of the Rajya Sabha. Due to its federal character, Rajya Sabha has been given two exclusive and special powers that are not enjoyed by the Lok Sabha. First, it can authorize the Parliament to make a law on a subject enumerated in the State List, Article 249. Second, it can authorize the Parliament to create new all India services common to both the centre and the states, Article 312. An analysis of the above points make it clear that the position of the Rajya Sabha in our constitutional system is not as weak as that of the House of the Lords in the British constitutional system, nor as strong as that of the Senate in the American constitutional system. except in the financial matters and control over the Council of Ministers. The powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Even though the Rajya Sabha has been given less powers as compared with the Lok Sabha, its utility is supported on the following grounds. It checks hasty, defective, careless, and ill-considered legislations made by the Lok Sabha by making provisions of revision and thought. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the center. Public Accounts Committee. Public Accounts Committee. This committee was set up first in 1921 under the provisions of the Government of India Act 1919 and has since been in existence. At present, it consists of 22 members, 15 from LS and 7 from RS. The members are elected by the Parliament every year from amongst its members according to the principle of proportional representation by means of a single transferable vote. Thus, all parties get due representation in Public Account Committee. The terms of the office of the members is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker from amongst its members. Until 1966-67, the chairman of the committee belongs to the ruling party. However, since 1967, a convention has developed whereby a chairman of the committee is selected invariably from the opposition. The function of the committee is to examine the annual audit reports of the CAG, which are laid before the Parliament by the President. The CAG submits 3 audit reports to the President, namely the audit report on the appropriation accounts, audit report on the finance accounts, and the audit report on the public undertakings. The committee examines public expenditure not only from the legal and formal point of view to discover technical irregularities, but also from the point of view of economy, prudence, wisdom, and propriety to bring out the cases of waste, loss, corruption, extravagance, inefficiency, and nugatory expenses. In more detail, the functions of the committee are to examine the appropriation accounts and the finance accounts of the union government and any other accounts laid before the Lok Sabha. The appropriation accounts compare the actual expenditure with the expenditure sanctioned by the Parliament through the Appropriation Act, while the finance accounts shows the annual receipts and disbursements of the union government. In scrutinizing the appropriation accounts and the audit report of the CAG on it, the committee has to satisfy itself that the money that has been disbursed was legally available for the applied service or purpose. The expenditure conforms to the authority that governs it, and every reappropriation has been made in accordance with the related rules. To examine the accounts of the state corporations, trading concerns, and manufacturing projects, and the audit report of the CAG on them, except those public undertakings which are allotted to the Committee on the Public Undertakings. To examine the accounts of autonomous and semi-autonomous bodies, the audit of which is conducted by the CAG. To consider the report of the CAG relating to an audit of any receipts or to examine the accounts of stores and stocks. To examine money spent on any service during a financial year in excess of the amount granted by the Lok Sabha for that purpose. In the fulfillment of the above functions, the committee is assisted by the CAG Estimates Committee. The origin of this committee can be traced to the Standing Financial Committee set up in 1921. The first Estimates Committee in the post-independence era was constituted in 1950 on the recommendations of the John Mathai, the then Finance Commissioner. Originally, it had 25 members, but in 1956, its members was raised to 30. All the 30 members are from the Lok Sabha only. The Rajya Sabha has no representation in the Estimates Committee. These members are elected by the Lok Sabha every year from amongst its members according to the principles of proportional representation by means of a single transferable vote. Thus, all the parties get due representation in it. The term of the office is 1 year. A minister cannot be elected as a member of the Estimates Committee. The chairman of the committee is appointed by the speaker from amongst its members, and he is invariably from the ruling party. The function of the committee is to examine the estimates included in the budget and suggest economies in public expenditure. Hence, it has been described as a continuous economic committee. In more detail, the functions of the committee are to report what economies improvements in organization, efficiency, and administrative reform consistent with the policy underlying the estimates can be effected. to suggest alternative policies in order to bring about efficiency and economy in the administration, to examine whether the money is well leaked out within the limits of the policy implied in the estimates, to suggest the form in which the estimates are to be presented to the Parliament. The committee continues the examination of the estimates from time to time throughout the financial year and report to the House as its examination proceeds. It is not incumbent on the committee to examine the entire estimates of any one year. The demands for grants are finally voted despite the fact that the committee has made no report. Committee on Public Undertakings. The Committee on Public Undertakings was created in 1964 on the recommendations of the Krishna Menon Committee. Originally, it had 15 members, 10 from LS and 5 from RS. However, in 1974, its membership was raised to 22, 15 from LS and 7 from RS. The members are elected by the Parliament every year from amongst its members according to the principle of proportional representation by means of a single transferable vote. Thus, all parties get due representation in it. The term of office of the members is 1 year. A minister cannot be elected as the members of the Committee on Public Undertaking. The chairman of the committee is appointed by the Speaker from amongst its members who are drawn from the Lok Sabha only. The members of the committee who are from the Rajya Sabha cannot be appointed as the chairman. The members of the committee who are from the Rajya Sabha cannot be appointed as the chairman. The functions of the committee are to examine the reports and accounts of the public undertakings, to examine the reports of the Comptroller and Auditor General on the public undertakings, to examine whether the affairs of the public undertakings are being managed in accordance with sound business principle and prudent commercial practices, to exercise such other functions vested in the Public Accounts Committee and the Estimates Committee in relation to the public undertakings which are allotted to it by the Speaker from the time to time. The committee is not to examine and investigate any of the following. First, the matters of major government policy as distinct from the business or commercial functions of the public undertakings. Second, matters of day-to-day administration. Third, matters for the consideration of which machinery is established by any special statute under which a particular public undertaking is established. Next, Departmental Standing Committee. On the recommendations of the Rules Committee of the Lok Sabha, 17 departmentally related standing committees were set up in 1993. In 2004, 7 more such committees were set up, thus increasing their number from 17 to 24. The standing committees assist the Parliament in debating the budget more effectively. The main objective is to secure more accountability of the executive to the Parliament, particularly financial accountability. The 24 standing committees cover under their jurisdiction are all the ministers' departments of the central government. Each standing committee consists of 31 members, 21 from LS and 10 from RS. The members of the LS are nominated by the Speaker from amongst its members, while the members of the RS are nominated by the Chairman from amongst its members. A minister is not eligible to be nominated as a member of any of the standing committees. In case a member, after his nomination to any of the standing committee, is appointed as a minister, he then ceases to be a member of the committee. The term of each standing committee is 1 year from the date of its constitution. Out of the 24 standing committees, 8 committees work under the Rajya Sabha and 16 committees work under the Lok Sabha. The functions of each of the standing committees are to consider the demands for the grants of the concerned ministries, departments before they are discussed and voted in the Lok Sabha. Its report should not suggest anything of the nature of cut motions. Second, to examine bills pertaining to the concerned ministries' departments, to consider annual reports of ministries and departments, to consider national basic long-term policy documents presented to the houses. The limitations that are imposed on the functioning of these houses committees are: first, they should not consider the matters of day-to-day administration of the concerned ministries' departments. They should not generally consider the matters which are considered by other parliamentary committees. It should be noted here that the recommendations of these committees are advisory in nature and hence not binding on the Parliament. The merits of the standing committee system in the Parliament are: their proceedings are devoid of any party bias. The procedure adopted by them is more flexible than in the Lok Sabha. The system makes parliamentary control of the executive much more detailed, close, continuous, in-depth, and comprehensive. The system ensures economy and efficiency in public expenditure as the ministers' departments would now be more careful in formulating their amendments. They facilitate opportunities to all the members of the parliament to participate and understand the functioning of the government and contribute to it. They can avail of expert opinion on they can avail of expert opinion or public opinion to make the reports. They are authorized to invite experts and eminent persons to testify before them and incorporate their opinions in their reports. The opposition parties and the Rajya Sabha can now play a greater role in exercising financial control over the executive. Business Advisory Committee. Business Advisory Committee, it regulates the program and timetable of the House. It allocates time for the transaction of the legislative and other business brought before the House by the government. The Lok Sabha Committee consists of 15 members including the Speaker as its chairman. In the Rajya Sabha, it has 11 members including the chairman as its ex officio chairman. Committee on Private Members, Bills and Resolutions. It classifies the bills and allocates time for the discussion of the bills and resolutions introduced by the private members, that is, other than ministers. This is a special committee of the Lok Sabha and consists of 15 members including the deputy speaker as its chairman. The Rajya Sabha does not have such a committee. The same functions in the Rajya Sabha is performed by the Business Advisory Committee of that House. Committee on Government Assurance. Examine the assurances, promises and undertakings given by the ministers from time to time on the floor of the House and reports on the extent to which they have been implemented. In the Lok Sabha, it consists of 15 members in the Rajya Sabha it consists of 10 members. It was constituted in 1953. Committee on Subordinate Legislation. The Committee on Subordinate Legislation examines and reports to the House whether the power to make regulations, rules, sub-rules and bylaws delegated by the Parliament or conferred by the Constitution to the executive are being properly exercised by it. In both the houses, the committee consists of 15 members. It was constituted in 1953. Committee on Welfare of SC and STs. It consists of 30 members, 20 from LS and 10 from RS. Its functions are to consider the reports of the National Commission for the SC and National Commission for ST, to examine all the matters relating to the welfare of SC and ST like implementation of constitutional and statutory safeguards, working of welfare programs, etc. Committee on Absence of Members. Committee on Absence of Members considers all applications from members for leave of absence from the sitting of the House and examines the cases of members who had been absent for a period of 60 days or more without permission. It is a special committee of the Lok Sabha and consists of 15 members. There is no such committee in the Rajya Sabha and all such matters are dealt by the House itself. Rules Committee. Rules Committee considers the matters of the procedure and the conduct of the business in the House and recommends necessary amendments or additions to the rules of the House. The Lok Sabha Committee consists of 15 members including the Speaker as its ex officio chairman. In Rajya Sabha, it consists of 16 members including the chairman as its ex officio chairman. General Purpose Committee. General Purpose Committee considers and advises on matters concerning affairs of the House, which do not fall within the jurisdiction of any other parliamentary committee. In each House, the committees consist of the presiding officer as its ex officio chairman, deputy speaker, deputy chairman in case of Rajya Sabha, members of the panel of the chairpersons, that is panel of the vice chairpersons in the case of the Rajya Sabha, and chairpersons of all the departmental standing committees of the House, leaders of the recognized parties and groups in the House, and such other members as nominated by the presiding officer. Committee of Privileges. Committee of Privileges functions as semi-judicial in nature. It examines the cases of breach of privileges of the House and its members and recommends appropriate action. The Lok Sabha Committee has 15 members while the Rajya Sabha Committee has 10 members. Joint Committee on Salaries and Allowances of Members. It was constituted under the Salary, Allowances and Pensions of the Members of the Parliament Act 1954. It consists of 5 members, 10 from Lok Sabha and 5 from Rajya Sabha. It frames rules for regulating payment of salaries, allowances and pensions to the members of the Parliament. House Committee. House Committee deals with the residential accommodation of the members and other amenities like the food, medical aid, etc. according to them in their houses and hostels in the Delhi. Both the houses have their respective house committees. In the Lok Sabha, it consists of 12 members. Committee on Petitions. Committee on Petitions examines petitions on the bills and on the matters of general public importance. It also entertains representatives from the individual and associations on the matters pertaining to the union budget. Committees on Petitions examines petitions on the bills and on the matters of the general public importance. It also entertains representations from the individuals and associations on matters pertaining to the union subject. The Lok Sabha committee consists of 15 members, while the Rajya Sabha committee consists of 10 members. Library Committee. Library Committee considers all the matters relating to the library of the Parliament and assists the members in utilizing the library services. It consists of 9 members, 6 from the Lok Sabha and 3 from the Rajya Sabha. Ethics Committee was constituted in the Rajya Sabha in 1997 and the Lok Sabha in 2000. It reinforces the code of conduct of the members of the Parliament. Ethics Committee examines the cases of misconduct and recommends appropriate action. Thus, Ethics Committee is engaged in maintaining discipline and decorum in the Parliament. Committee on Empowerment of Women was constituted in 1997 and consists of 30 members, 20 from the Lok Sabha and 10 from the Rajya Sabha. Committee on Empowerment of the Women considers the reports of the National Commission for Women and examines the measures taken by the Union government to secure states' dignity and equality for women in all the fields. Committee on Papers laid on the table. It was constituted in the 1975. The Lok Sabha committee has 15 members, while the Rajya Sabha committee has 10 members. It examines all the papers laid on the table of the House by the ministers to see whether they comply with provisions of the Constitution, Act or rule. It does not examine statutory notifications and orders that fall under the jurisdiction of the Committee on Subordinate Legislation. Joint Committee on Office of Profit. Joint Committee on Office of Profit examines the composition and character of the committees and other bodies appointed by the central, state and union territory governments and recommends whether persons holding these offices should be disqualified from being elected as members of the Parliament or not. It consists of 15 members, 10 from the Lok Sabha and 5 from the Rajya Sabha. Consultative Committees. The consultative committees are attached to various ministries' departments of the central government. The consultative committees are attached to various ministries' departments of the central government. Consultative committees consist of members of both the houses of the Parliament. The minister or the Minister of State in charge of the ministry concerned acts as the chairman of the consultative committee of that ministry. These committees provide a forum for informal discussions between the ministers and the members of the Parliament on the policies and programs of the government and the manner of their implementation. These committees are constituted by the Ministry of Parliamentary Affairs. The guidelines regarding the composition, functions and procedure of these committees are formulated by the Ministry of Parliamentary Affairs. The Ministry also makes arrangements for holding their meetings both during the session and the intersession period of the Parliament. These committees are normally constituted after the Lok Sabha these committees are normally constituted after the new Lok Sabha is constituted after general elections of the Lok Sabha. After the constitution of the 14th Lok Sabha, 29 consultative committees were constituted in October 2004. Subsequently, 3 more consultative committees were constituted, thus raising their number to 34. In addition, the separate informal consultative committees of the members of the Parliament are also constituted for all the railway zones. The members of the Parliament belong to the area falling under the particular railway zone are nominated on the informal consultative committee of that railway zone. After the constitution of the 14th Lok Sabha, 16 informal consultative committees for the 16 railway zones have been constituted. Unlike the consultative committees attached to the various ministries' departments, the meetings of the informal consultative committees are to be arranged during the sessions period only. Parliamentary privileges. Meaning, parliamentary privileges are special rights, immunities and exemptions enjoyed by the two houses of the Parliament, their committees and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the houses can neither maintain their authority, dignity and honor, nor can protect their members from any obstruction in the discharge of their parliamentary responsibilities. The Constitution has also extended the parliamentary privileges to those persons who are entitled to speak and take part in the proceedings of a House of Parliament or any of its committees. These include the Attorney General of India and the Union Ministers. It must be clarified here that the parliamentary privileges do not extend to the President, who is also an integral part of the President. Who is an integral part of the Parliament? Why? It must also be clarified here that the parliament privileges do not extend to the President, who is also an integral. It must be clarified here that the parliamentary privileges do not extend to the President, who is also an integral part of the Parliament. Classification: Parliament privileges can be classified into two broad categories. Those that are enjoyed by each house of the Parliament collectively. Second, those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each house of the Parliament collectively are: first, it has the right to publish its reports, debates and proceedings, and also the rights to prohibit other from the publishing the same. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of the parliamentary proceedings without prior permission of the House, but this is not applicable in the case of a secret sitting of the House. Second, it can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. Third, it can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. Fourth, it can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition, or imprisonment, also suspension or expulsion in such case of members. Fifth, it has the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member. Sixth, it can institute inquiries and order the attendance of witnesses and send for relevant papers and records. Seventh, the courts are prohibited to inquire into the proceedings of a house or its committees. Eighth, no person, either a member of or the outsider, can be arrested, and no legal person, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: first, they cannot be arrested during the session of the Parliament and 14 days before the beginning and 14 days after the end of the session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. Second, they have the freedom of speech in the Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in the Parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules of and standing orders regulating the procedure of the Parliament. Third, they are exempted from jury service. They refuse to give evidence and appear as a witness in a case pending in a court when the Parliament is in session. They can refuse. Breach of privileges and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights, and immunities, either of the members individually or of the House in its collective capacity, the offence is termed as the breach of the privilege and is punishable by the House. Any act or omission which obstructs a House of the Parliament, its members, or its officers in the performance of their functions, or which has a tendency, directly or indirectly, to produce results against the dignity, authority, and honor of the House, is treated as a contempt of the House. Though the two phrases breach of the privileges and contempt of the House are usually interchangeably used, they have different implications. Normally, a breach of the privilege may amount to contempt of the House. Likewise, a contempt of the House may include the breach of the privilege also. Contempt of the House, however, has a wider implication. There may be a contempt of the House without specifically committing a breach of the privilege. Similarly, actions which are not breaches of any specific privilege but are offences against the dignity and authority of the House amount to contempt of the House. For example, disobedience to a legitimate order of the House is not a breach of the privilege but can be punished as a contempt of the House. Sources of privileges. Originally, the Constitution under Article 105 expressly mentions two privileges, that is, freedom of speech in the Parliament and right of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of Commons, its committees and its members on the date of its commencement, that is 26 January 1950 until defined by Parliament. Sources of privileges. Originally, the Constitution Article 105 expressly mentioned two privileges, that is freedom of speech in the Parliament and right of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of the Commons, its committees and its members on the date of its commitment, that is 26 January 1950 until defined by the Parliament. The 44th Amendment Act of 1978 provides that the other privileges of each of the House, its committees and its members are to be those which they had on the date of the commencement, that is 20 June 1979, until defined by the Parliament. This means that the position with regard to other privileges remains same. In other words, the amendments has made only verbal changes, dropping a direct reference to the British House of Commons without making any change in the implications of the provisions. It should be noted here that the Parliament till now has not made any special law to exhaustively codify all the privileges. They are based on the 5 sources, namely Constitutional provisions, various laws made by the Parliament, rules of both the houses, parliamentary conventions and judicial interpretations. Sovereignty of the Parliament. The doctrine of the sovereignty of the Parliament is associated with the British Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. There are no legal restrictions on its authority and jurisdiction. Therefore, the sovereignty of the Parliament, parliamentary supremacy, is a cardinal feature of the British constitutional system. According to A.V. Dicey, the British jurist, this principle has 3 implications. The Parliament can make, amend, substitute or repeal any law. Dale Olme, a British political analyst, said, the British Parliament can do everything except make a woman a man and a man a woman. Second, the Parliament can make constitutional laws by the same procedure as ordinary laws. In other words, there is no distinction between the constituent authority and the legislative authority of the British Parliament. Third, the parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in the Britain. The Indian Parliament, on the other hand, cannot be regarded as a sovereign body in the similar sense as there are legal restrictions on its authority and its jurisdiction. The factors that limit the sovereignty of the Indian Parliament are: first, written nature of the Constitution. The Constitution is the fundamental law of the land in our country. It has defined the authority and the jurisdiction of all the 3 organs of the Union government, the nature of the interrelationship between them. Hence, the Parliament has to operate within the limits prescribed by the Constitution. There is also legal distinction between the legislative authority and the constituent authority of the Parliament. Moreover, to effect certain amendments to the Constitution, the ratification of half of the states is also required. In Britain, on the other hand, the Constitution is neither written nor there is any like a fundamental law of the land. Second, the federal system of the government. India has a federal system of the government with the constitutional constitutional divisions of powers between the Union and the states. Both have to operate within the spheres allotted to them. Hence, the law-making authority of the Parliament gets confined to the subjects enumerated in the Union list and concurrent list and does not extend to the subjects enumerated in the state list, except in 5 abnormal circumstances, and that too for a short period. Britain, on the other hand, has a unitary system of government and hence all the powers are vested in the centre. Third, system of judicial review. The adoption of an independent judiciary with the power of judicial review also restricts the supremacy of the Parliament. Both the Supreme Court and High Courts can declare the laws enacted by the Parliament as void and ultra vires unconstitutional if they contravene any provision of the Constitution. On the other hand, there is no system of judicial review in Britain. The British courts have to apply the parliamentary laws to specific cases without examining their constitutionality, legality or reasonableness. Fundamental rights. The authority of the Parliament is also restricted by the incorporation of Code of Justiciable Fundamental Rights under Part 3 of the Constitution. Article 13 prohibits the state from making a law that either takes away totally or abrogates in part a fundamental right. Hence, a parliamentary law that contravenes the fundamental rights shall be void. In Britain, on the other hand, there is no codification of justiciable fundamental rights in the Constitution. The British Parliament has also not made any law that lays down the fundamental rights of the citizens. However, it does not mean that the British citizens do not have rights. Though there is no charter guaranteeing rights, there is maximum liberty in Britain due to the existence of the rule of the law. Therefore, even though the nomenclature and organizational pattern of our parliament is similar to that of the British Parliament, there is substantial difference between the two. The Indian Parliament is not a sovereign body in the sense in which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited, and restrained. In this regard, the Indian Parliament is similar to the American legislature known as the Congress. In USA also, the sovereignty of the Congress is legally restricted by the written character of the Constitution, the federal system of the government, the system of judicial review, and the Bill of the Rights.